Welcome everyone to the Tonkin Legal Group, home of the Australian Family Law Podcast, the AFLP. Definitely not the official podcast of the Australian Football League. It is I, as always, Joe, joined by St John. G'day, St John.
G'day, Joe. G'day, Charlie.
G'day, St John. Joe, how are we?
Good, mate. Good.
Good to be back.
Absolutely.
To be here. Yeah.
I'm sure it's amazing that we got here. The amount of noise and the hysteria that was banging down our door during this week because there was no episode last week was quite terrifying. But it's all right, guys. Everything is right in the world. We're back again. We just weren't available last week, and we've got a good one. A lot has happened since our last podcast. There's been a really big controversy. There's been a new coach appointment. A lot's happened in the world of footy since our last podcast, hasn't it, SH?
It has, yes, it has. And got two new coaches, I think, because you've got Fraser as well, although he's not new, but he's now on permanently. And I don't think we need to bring up the unsavoury happenings at Richmond's Mad Monday. I mean, Sydney's foray into the Pullman last week, which goes without saying. Respect for women is the highest priority, and that needs to be sacrosanct. And I think those chaps let the team down dramatically.
Yeah, absolutely. I think it's time will tell, but not good at all. And as you said, SH, I think respect for women is the most important thing to come out of this. So good point to raise. But yeah, a lot has happened in footy in the last couple of weeks. So Joe, you were just touching on your new coach, Big Spike McVeigh off air. You were pretty happy about it?
Look, he wasn't my first choice, as you know. Definitely very much was in the Jamie Graham camp. I've always maintained that I wanted Jamie Graham. He's got a great apprenticeship and he's done an amazing job at Fremantle, and I'd love for him to bring that across to the Bombers. But we know we've stuck fat, I guess, and committed to the Essendon person. And the Essendon person is not James Hird, much to his chagrin. It was, in fact, Spike McVeigh. And look, whilst it wasn't my decision, got to back him in now. Got to put our arms around him, around the club, and really hope that he's got a 3-year contract. Well, let's hope he's around for 10, because it means that he's getting us into contention and playing good football. Only, as you said about the Pullman 5, only time will tell, and we'll see what happens with that. And obviously, I think there was a statement came out about Richmond just before today that the adamant that it was not in reference to the Pullman incident.
No, let's not go there, shall we? It's a blight on the AFL landscape, and we need to move on. But obviously, the ripple effect's going to be long or everlasting. It's ruined the culture at the Bloods. But Joe, coming back to your coach, Tim Watson, this morning on SEN, it was very clear. He said, "Look, we've made a decision. The crowd and the supporters should get behind the club and not lament the loss or the non-appointment of James Hird. So rally around and be supportive of the new coach." And I think that's the message, isn't it? It is what it is. You've chosen your coach. Let's back him and see how he goes.
Yeah, exactly. And he's adopting a very young list, and it's going to get even younger. Merritt's probably out the door, and of course we still get to hold on to this bad boy. We did not give up this bad boy. Mwah! He's staying home. So we'll see what we do with it, and who we select.
Joe, I was watching the end of your game, and I was secretly thinking, no, do I want the wooden spoon? Yeah. Do I want pick number one, and then the reality set in, and the siren went, and we finished second last. So congratulations on another wooden spoon. I know it's not it's an ignominious award, but at the end of the day, it's an award. So wear it proudly. And we'll have that mounted in your room until the next season.
Yeah.
But what about the D's, Charlie? Falling over at the last hurdle,
Yeah,
playing a final, yet not a final until you win the not final until you make the finals.
they're definitely finals. I was against the wild card and against calling it a final, but no, absolutely, it has to be considered a final. The wild card. I mean, it's hard to get into a wild card position. We've butchered the end of the season. We had the chance to potentially sneak into the top four, and typical Melbourne, we've found a way to turn a really positive season into a disappointing end. I won't speak too soon, but I'm not overly confident against the Blues. Probably the worst time to get Carlton, and then on the flip side, it's probably the best time to get the D's, considering we're pretty decimated at the moment. But you never know.
It's at the G though. Your happy hunting ground there.
It's at the G. Only lost twice there this year, so. And Carlton are prone to not standing up in big games, so the heat will be onto them. They're favourites, so who knows? Who knows?
No Van Roy and no Melbourne. Or?
Potentially, although Wayne, I was going to call him Wayne Carey. Harrison Petty almost morphed into Wayne Carey for about 10 minutes against the Bulldogs.
I can see the likeness, yeah.
Yeah. So we've got.
I can see the connection.
Yeah, Wayne Petty.
The Duck
So
Petty.
anything's possible, yeah. But I don't know. It's going to be a tense Saturday night. I'm already not looking forward to it, to be honest. We'll see what happens.
Yeah, well, I suppose it does maintain the interest, doesn't it? And we don't have that horrible bye weekend. And it does let, teams like Richmond, who finished ninth for 38 years in a row, to get a leg up into the finals, potentially. So Joe's shaking his head. He's not happy. He's a traditionalist.
No,
he doesn't like it.
It's a cash grab. Everybody knows it's a cash grab. And I've maintained right from the start. You increase the number of competitors into the finals, but you are essentially reducing the number of genuine contenders, because good luck if you're 7 or 8. It was already hard enough as it is, and now you have to play an extra game whilst everybody else has the week off. So
true.
I've always been against it, but well, it's certainly giving us, though, potentially a really exciting week of football to come. 2 cracking games, your doggies, SH.
Oh, yep, my doggies.
Got to back them in, and
yeah. Well, I hope so, and I hope Norton plays, but bit unsure about English. So that could be a big hole in the ruck department. But look, the doggies, I thought they did well against the D's. I didn't think they would beat the D's. So let's hope they can roll the Pies, though, because the Pies have been living on their laurels for far too long.
I think the AFL will be pretty happy that Carlton and Collingwood have stumbled into a wild card. That'll be good for their bank accounts, I'm sure.
Would have been nice, though, had they played together or against each other, because at least one of them would have got kicked out. But at the end of the day, if Carlton and Collingwood progress, it's all the D's and my doggies' fault.
It is. Well, it's our fault that the AFL has missed out on a Carlton Collingwood wild card, so we've got to live with that.
Exactly right. And, brings us to the topic here of our podcast, continuing on our latest series of going to court, all the steps involved. We've discussed the pre-action procedures. We've discussed the attempt or the requirement to make a genuine attempt to resolve your matter, going to a mediation, some family dispute resolution. And now you haven't been successful, your matter hasn't resolved, you've been given a Section 60I certificate by the mediator, and what is your next step? Well, it is to issue proceedings, and that is where we will start today with our rules of the game. So here we are, gentlemen, talking about how we go about issuing proceedings in the Federal Circuit and Family Court of Australia. It will be, of course, for either parenting or property. You got to prepare those documents, file those documents, and then have them be delivered to your ex so that they can be made aware of the proceedings. So I guess we'll start off with SH. What would be the really, I suppose, key integral documents that need to be drafted every time?
Sure, and I think I might just pick up on one of your phrases there, Joe. Issuing proceedings. As family lawyers or as lawyers, we all know what that means. But to those who are listening, issuing proceedings means to start a court matter. And the only way you can start a court matter is file various documents with the court. In property and parenting matters, the main documents are an affidavit, which sets out your evidence. So it's your written statement about the circumstances of your relationship and your asset pool. A financial statement, which details all the finances of the parties. And of course, an application. Now, an application is your wish list. It's a list of things or orders that you would like the court to make on a final and or an interim basis. So they're the three main documents. There are some ancillary documents like a notice of child abuse or family violence, a genuine step certificate, things of that nature. But the main ones, an affidavit, an application, and a financial statement.
Exactly right.
Charlie, what happens when you've got all those? What happens when you've got all those documents together? They've been signed, and an affidavit needs to be signed in the presence of a lawyer or another appropriate witness. What happens to the documents then?
Well, once they're signed, we need to file them. So the documents get filed with the courts. There's an online portal called the Commonwealth Courts portal. We won't go into too much detail there because I don't want to put everyone to sleep. But basically, that's the place where we go to file the documents, and then after they're filed, we receive what's called sealed versions of the documents, which essentially has the court's seal, and then, as we know, the documents, once they've been filed and sealed, we then need to serve them. And I think, Joe, that probably leads us into the next topic, or I might be wrong there.
Yeah, exactly. Oh, you're getting better at this, Charlie. You honestly.
Thank you. What a segue.
You are a born presenter.
Lovely segue,
Let's move on to Ask the Umpire. So here we are, asking the umpire. Perfect segue there by Mr. Crobinson himself. SH, how does an applicant go about serving the other party once they've filed their documents?
Well, service is an important component of the process, and unless you do it properly, technically your matter doesn't exist. So the proceedings or the court matter, together with the documents you've filed on the Commonwealth portal, need to be brought to the attention of the other party. There are various ways of doing that. You can use a process server who finds the person that you're trying to serve the documents with, whether that be your ex-partner or wife, husband, etc. And they then will provide an affidavit of service or a document proving that the court documents have been handed to the other party. The other way of serving documents is if someone's solicitor has agreed to accept service of those documents on behalf of their client, which is the standard practice in most of our matters, where there are lawyers involved, and we commence court proceedings, file our documents, and then serve them on the other solicitor who has already or previously agreed to accept service of those documents. one of our colleagues was involved in a matter the other day where service couldn't be proved or proven, so the matter couldn't proceed. So it's an important component in the step of this court process.
And then, St John, once someone has been served with court material or initiating material, how long, well, as we know, that person becomes the respondent in that matter, how long would the respondent have to file their responding material?
Yeah, good question. And that raises two issues. One is once you've filed your application, your affidavit and your financial statement, served it on the other side, that person has the right to provide their own affidavit, their own financial statement, and a response to your application, which is their wish list of what they want the court to order. 28 days, Charlie, from the date you are
28.
served. So if I'm acting for a husband and we're serving his wife, that the wife has 28 days from the date of service to file her responding material with the court and serve it upon us. Now, invariably, as we've discovered in these matters, time limits are not always adhered to, especially by the court, but where possible, we like to have or ensure our clients come to court with clean hands and abide by the proper rules and regulations.
And obviously would depend as well whether or not the applicant, the initiating, party got their application for an urgent listing granted, for example. Obviously, in those circumstances, you could end up with a really short turnaround for a hearing, and obviously that 28-day period sort of goes by the wayside because you'll be given orders to provide your documents even sooner. But obviously those tend to be the exceptions, and it's really hard to get an urgent listing without move to the fact or furphy. All right, SH, give us a couple of facts or furfies, please.
Are you ready? Fact or
Ready.
furphy?
All right.
I always go to say fact or fiction, but all right, Joe, cram all the information you want into your affidavit because there's no page restriction. So your affidavit's your written statement to the court. You can put in as many pages as you want, can't you?
No, you cannot. That is a furphy. In fact, you are limited to only 10 pages in length for your initiating or responding affidavit. You can only have 10 pages to do so. And people always or are recommended whenever they're giving their side of the story to also provide documented evidence to support their statement. These are called annexures. They are annexed towards the back of the affidavit. So not only do you have a limitation of 10 pages for your affidavit, you also have a limitation to how many annexures you can have, and that is being 5. Unless, of course, you seek leave of the court to rely on more pages. If you do not get that, if you do not seek leave, then you can, of course, put it to the other party. Which of these 10 pages do you seek to rely on? Or in other words, say, pick your poison, or in other words, another opportunity to have is to remove their filed affidavit of more than 10 pages and re-upload another one that is actually compliant. So it is a furphy. You don't have infinite length. It's limited to 10 and 5 annexures.
Thank you, Joe. 100% correct. Now, Charlie, fact or furphy? You've filed your documents at the court, you've filed your affidavit, your application and your financial statement, and you're looking to serve your client's former husband, and he has a solicitor. Can you just simply drop the documents on an email to the husband's solicitor and assume that that's proper service of those documents?
Well, you definitely can't assume. So I would say to answer that, it's a big fat furphy. So now the rules of service obviously need to be complied with, and St John, like you explained earlier, we would firstly need to confirm with the other party's lawyer if they have instructions to accept service on behalf of their client. If they do confirm that in writing, which is generally the case in our practice, then yes, we can then send by email to the other side's lawyer. But if they don't confirm in writing that they have instructions to accept service, then in that instance, the other party may need to be personally served. So we need to go down the path of the process server, who, it's a professional who actually goes off and personally serves the other party or physically hands them the court documents. So yeah, where the rules of service always prevail and need to be complied with.
Yep, good answer, and again, 100% correct, as Joe was.
On you, boys.
Amazing.
Are we ready to move on to play on or blow the whistle?
I think we are.
Alrighty, let's go. Play on or blow the whistle. This is one of those classic drama scenes that you tend to see in these high-profile TV shows and stuff where, picture this, a husband comes in, he's absolutely furious at his wife. He says he's had enough. He's had enough. All these years of heartache and headaches and financial strain, he's done, and he wants to see her in court. He pulls out the papers, drops them on the kitchen table in front of her and says, "I'll see you in court tomorrow." Is that a play on, or do you blow the whistle?
Blow the whistle. Blow the
Blow
whistle.
the whistle. Blow the whistle.
Clearly, I mean, certainly the rules say a husband can't serve a wife and a wife can't serve a husband. So it has to be done through an intermediary. So that's rule number one. And rule number two is not a good idea to be serving documents on former partners.
Yeah.
So no, that is definitely blow the whistle. Charlie?
And yeah, I mean, under the court rules, the documents need to be served as soon as possible or as soon as practicable after filing, or I think it's at least 7 days before the actual hearing of the application. So yeah, doing that is a little bit sneaky, and it's not going to comply with the rules. And I would imagine in that instance, the court would most likely adjourn the matter to allow the respondent enough time to actually respond and prepare their response material.
Beautiful. We now move on to our honest predictions. Only 2 games to discuss this week, gentlemen, because we're now in the wild card round, and we start off with the Friday night matchup with your beloved doggies, SH, up against the Dirty Pies at 7:40 p.m. Are we?
Yes.
I'm concerned. I think the Pies win this game.
I agree. I'm concerned. The doggies just look a little thin on the ground. So as much as it goes against every fibre of my being, I believe Collingwood will be too strong. They're just too well coached, too well drilled. But without Pendlebury, they're only half the team they used to be. So, Charlie?
And, well, they're also without our good buddy Maynard, that criminal. But I think...
Career killer, yeah.
Curricula, yep. I think a lot of it depends on selection. If Norton plays, I think I'd be very tempted to back the doggies. If he doesn't, I'll go the Pies. So that's my prediction.
Yeah, he's an integral part, isn't he? What about you, Joe?
Yeah, I've tipped the Pies.
Tip the Pies.
Yeah.
By how many?
I'm going to go the Pies by 13.
Pies by 23.
Dogs by 5 points if Norton plays. Pies by 5 points if Norton doesn't play.
Ooh, okay. Having a bet each way.
Norton is the equivalent of 10 points.
I'd say so, yeah. Minimum.
There you go. All right. Brace yourself. We're now talking about your boys, the D's. up against the Blues, Saturday, 7:35 p.m.
Ooh.
Oh, SH, what if we were discussing this a month ago or 3 weeks ago? It was a very different story, wasn't it?
It was, and it is. But I'm deferring to you, Charlie. I want to hear what you have to say.
Well, yeah, like I said earlier, I think it's probably the worst time to get the Blues and the best time to get the Ds. We're pretty decimated. I'd be surprised if if Carlton didn't beat us by any less than 30 points. I think it's going to be the Blues by at least 5 goals. We're running too thin, too many key outs. So yeah, Blue Baggers by 30. More heartbreak for the Ds.
D's by 7. That's it. D's by 7.
Leads back off.
Yep. No, Carlton's run is over.
Yes.
Their cup runneth over.
They got their coach, and that's it. No more.
That's
They,
it.
they got sucked in with the interim coach again. Just
Yes.
Teague all
The
over
Teague
again.
train, yeah.
Yeah.
No, well, I think they're going to lose their first non-final final, and it's going to be all in vain. So, and Melbourne live on to fight another day,
Yeah.
and
well-
probably get a game in Adelaide or something like that.
Yeah. That's all right. Well, we don't lose at the big house at the G, so unless it's against the Dogs.
Joe?
Or Geelong.
Or
I'm
Geelong.
tipping the Blues here. Sorry, Charlie. I
Fine,
think
mate,
the
so am
Blues
I.
are in ripping hot form. They're in really good form at the moment. They're up and about. They can probably smell blood at the moment, and they're probably chomping at the bits. Big Carlton contingent to hit the G. Will be loud. It will be obnoxious. It will be insufferable, and they will move on to the next week. And there's nothing I can do about it, but console myself to bed with my beloved wooden spoon. So they can take away a lot
You're
of
a good
things, but
sport.
they can't take away the spoon. So on that note, ladies and gentlemen, thank you all so much for watching. If you enjoyed what you had to see or hear from us today, please make sure that you like, subscribe, hit the notification bell to not miss out on any of our episodes. And if you're listening to us on Spotify, please rate us 5 stars. All of these are very small, free, easy actions for you to do, but it goes a long way for our outreach and to continue to spread the word and to demystify family law for the general public. St. John and Charlie, as always, it was an absolute pleasure.
You too, Joe. Absolute pleasure as always.
Thanks, guys. Great fun.
Thanks,
Good luck,
guys. Go
Days.
Go Ds.
Go Days.